Jasmine Richardson. Inside a school locker in Medicine Hat, Alberta, a teacher found a drawing. It was done in stick figures, simple and childlike, and it showed a family being harmed. The girl who drew it was 12 years old. Within days, police would discover that the drawing was not a fantasy, it was a plan. And by the time anyone found it, 3 people in that family were already gone. It was 2006, and Jasmine Richardson was the youngest of the Richardson family, living in a quiet neighborhood in Medicine Hat. Her parents, Mark and Deborah, were former addicts who had rebuilt their lives, gotten sober, and moved from Calgary the year before to start fresh. They had an 8-year-old son named Jacob. From the outside, the Richardsons looked like a family that had done the hard work of putting themselves back together. But Jasmine had been talking to someone online. Through goth-oriented social networking sites called Nexopia and Vampire Freaks, she had connected with a 23-year-old man named Jeremy Allen Stanky. The age gap alone should have been alarming, and when the Richardsons found out, they forbade the relationship immediately. That decision would cost them everything. On April 23, 2006, Steinke entered the Richardson home through a basement window wearing a neoprene mask. What followed was an attack that took the lives of Mark, Deborah, and young Jacob. Online messages introduced at trial later showed that the plan had been discussed in detail beforehand, with Jasmine writing to Steinke that her plan began with taking her family's lives and ended with the 2 of them living together. The pair watched the film Natural Born Killers shortly before, and were seen at a restaurant kissing just hours after. Police only found Jasmine after a friend of Jacob's looked through the basement window and glimpsed what had happened inside. The stick figure drawing in her locker shifted her status from missing person to suspect. By April 24th, both were arrested in Leader, Saskatchewan. Jasmine was tried in Calgary at the age of 14. On July 9, 2007, the jury convicted her of 3 counts of first-degree murder after roughly 3 hours of deliberation. Because she was under 14 at the time of the offense, Canada's Youth Criminal Justice Act capped her sentence at its statutory maximum of 10 years under an intensive rehabilitative custody and supervision order. That meant roughly 4 years in secure psychiatric custody, followed by supervised release into the community. The judge had no authority to impose anything longer, regardless of how many lives were taken. She could not be tried as an adult. Steinke, tried separately in December 2008, received 3 concurrent life sentences with no parole eligibility for 25 years. On September 27, 2011, a judge ruled Jasmine a low risk for violence and moved her to community supervision. She enrolled at Mount Royal University that fall. Then, on May 6, 2016, the judge lifted all court-ordered conditions, telling her that he believed her parents and brother would be proud of her. She did not receive clemency or a pardon. She served the statutory maximum. Her youth criminal record was expunged in 2020 under standard provisions. The case reignited debate across Canada about the 10-year sentencing cap for offenders under 14, regardless of how severe the crime. Supporters of the sentence, including criminologist Mark Totten and her legal team, described Jasmine as a poster child for rehabilitation. Critics, including some Medicine Hat residents and the former investigating inspector, argued the sentence was too lenient for 3 lives taken, one of them a child. The absence of a public apology at her final hearing only fed that skepticism. But under the law as written, the judge had no option to extend her time. Her lawyer told media in 2016 that the system had worked exactly as it was designed to. It also forced a public conversation about adult predation of minors online and about the role of conduct disorder and oppositional defiant disorder in her diagnostic profile. As of 2026, Jasmine Richardson is 32 years old, living under a new identity at an undisclosed Canadian location. No violations or reincarcerations have been reported. Steinke remains incarcerated, with his earliest parole eligibility around 2033. 3 lives ended because 2 teenagers were told they could not be together. One of those teenagers served 10 years. The other will serve at least 25. Whether those numbers feel proportional depends entirely on what you believe the justice system is supposed to do. And that question sits at the center of every case in this video, starting with a girl from Nashville whose story would eventually reach the White House. Cyntoia Brown. When a 16-year-old runaway is being trafficked by a man who calls himself Cutthroat, picked up by a 43-year-old stranger who pays $150 for sex, and then fires a single fatal shot in the middle of the night. The question of who is the victim and who is the offender is not as straightforward as a courtroom might suggest. And for Cyntoia Brown, the answer to that question would take 15 years, a viral campaign, and an act of executive clemency to sort out. On August 6, 2004, Cyntoia Brown, a 16-year-old runaway, was being controlled by a 24-year-old pimp in Nashville. That night, a 43-year-old real estate agent named Johnny Mitchell Allen picked her up at a Sonic drive-in and brought her to his home. What happened inside that house became the subject of 2 competing narratives that would define the next decade and a half. The prosecution argued premeditated murder and aggravated robbery. The fatal shot struck the back of Allen's head while he lay in bed, which they said proved he was asleep and posed no threat. Brown took roughly $172 from his wallet, 2 firearms, and his truck before fleeing. The defense told a different story. Brown said Allen had shown her multiple guns, grown physically aggressive, and appeared to reach for something beneath the bed. She fired because she believed her life was in danger. What the jury at her 2006 trial did not hear was evidence that would later prove critical. Brown's biological mother admitted to drinking up to a 1/5 of whiskey a day during her pregnancy. A subsequent diagnosis of fetal alcohol spectrum disorder was never presented to the court. On August 25, 2006, Brown was convicted on all counts and sentenced to life in prison. Under Tennessee's truth in sentencing law, that meant 51 years before she would even be considered for parole. The case might have ended there. But in 2011, a PBS documentary called Me Facing Life brought her story to a national audience. Then in November 2017, the hashtag #FreeCyntoiaBrown went viral after Rihanna, Kim Kardashian, LeBron James, and others amplified it across social media. A clemency hearing in May 2018 included testimony from the former prosecutor who had convicted her, Preston Shipp, who had since become her professor at Lipscomb University and now argued for her release. In December 2018, the Tennessee Supreme Court ruled she was legally required to serve the full 51 years, which closed off any judicial path to freedom. That meant Brown would not have been considered for parole until her late 60s. Executive clemency was the only option left. On January 7, 2019, Republican Governor Bill Haslam granted it, commuting her sentence. This was a commutation, not a pardon. Her conviction remains on her record, and she was placed on supervised parole for 10 years. In his clemency statement, Haslam acknowledged that there was more work to be done, especially with respect to the sentencing of juveniles. Brown was released on August 7, 2019, after serving about 15 years. While incarcerated, she earned her GED, an associate's degree, and a bachelor's degree in organizational leadership from Lipscomb University. She married Christian hip-hop artist Jaime Long, published a memoir that was nominated for an NAACP Image Award, and co-founded organizations focused on teen trafficking and juvenile justice reform. As of April 2026, Brown's parole continues through approximately 2029, with no reported violations. Tennessee's safe harbor law, changed in 2011, now bars prostitution charges against anyone under 18. At the time of Brown's arrest, the states still use the term teen prostitute. The Vera Institute has noted that 86% of incarcerated women have experienced abuse, a statistic that hangs over Brown's case and many others like it. Brown's case laid bare something the criminal justice system has never been comfortable with. When the person who pulled the trigger was also the person being exploited, which fact should carry more weight? Sarah Cruzan would have understood that dilemma better than most, because her answer came with a sentence that was never supposed to end. Sarah Cruzan. On the night a Riverside, California jury handed down its verdict, the judge looked at the 16-year-old girl standing before him and called her crime well thought out. He cited what he described as her lack of moral scruple. Then he sentenced her to life in prison without the possibility of parole, plus 4 years. She would never be eligible for release. She was the youngest female in California to receive that sentence, and the man she had taken the life of had been trafficking her since she was 13 and had first harmed her when she was 11. Sarah Cruzan's childhood reads like a catalog of what a system is supposed to prevent, but did not. She was harmed as a young child by her mother's boyfriend. Her mother, who struggled with drug addiction, admitted to bashing her daughter's head on the floor. By 9, Sarah had been hospitalized for psychiatric treatment. And then a man named George Gilbert Howard entered her life. He began grooming her when she was still a child, and by 13, she was being trafficked. On March 10, 1994, Sarah, then 16, shot Howard at the Dynasty Suites Motel in Riverside. She took roughly $1,500 from his wallet and the keys to his Jaguar. At trial, she testified that a man named James Earl Hampton had threatened to take the lives of her and her mother unless she carried out the act and brought back Howard's cash. Hampton was never charged. Her defense attorney was barred from fully presenting evidence of Howard's trafficking. The jury convicted her on May 11, 1995, of first-degree murder with special circumstances for robbery and lying in wait. The prosecutor had urged jurors not to be swayed by the appearance of an attractive, petite teenager. The judge imposed life without parole. 3 separate legal actions, spread across nearly 2 decades, would eventually undo that sentence. On January 2, 2011, outgoing Governor Arnold Schwarzenegger commuted her sentence to 25 years to life, writing that given her age at the time and the abuse she had suffered, the original sentence was excessive. Then in January 2013, after a California Supreme Court remand, her pro bono legal team at the firm Perkins Coie negotiated a reduction to second-degree murder with a 15-to-life sentence, making her immediately parole eligible. The parole board found her suitable in June 2013, and Governor Jerry Brown declined to reverse the grant. She was released on October 31, 2013, after 19 years at the Central California Women's Facility in Chowchilla. Then, on July 1, 2022, Governor Gavin Newsom issued a full pardon, a separate legal act that restores civil rights without expunging the conviction. Her case was not just about one girl. It helped catalyze 2 California statutes, the Fair Sentencing for Youth Act and a companion bill, both of which created resentencing mechanisms for juveniles serving long sentences and required parole boards to give special consideration to youthful offenders. Human Rights Watch featured her in its 2008 report that helped shift national attention to juvenile life without parole as a human rights issue. Sarah Cruzan now lives in California with her daughter, Summer. Her memoir, I Cried to Dream Again, received a starred review from Kirkus and an endorsement from a Nobel laureate. Her legal team has petitioned the Riverside County District Attorney to vacate the conviction entirely, and she is the public face behind proposed federal legislation known informally as Sarah's Law, which would protect trafficking survivors from life sentences for crimes connected to their abuse. As of 2026, she has had no reported violations. Her trajectory from life without parole at 17 to a full pardon at 44 traces one of the cleanest arcs in modern American juvenile justice reform. Newsom's pardon explicitly stated that it does not minimize or forgive her conduct or the harm it caused. A pardon and an apology are not the same thing. That tension was put to its most extreme test in Gary, Indiana, where a 15-year-old girl became the youngest person on death row in the United States. Paula Cooper. On May 14, 1985, a 78-year-old widow named Ruth Pelk answered her front door in Gary, Indiana. The people standing on her porch were 4 teenage girls from the local high school. They told her they were there to ask about Bible lessons. Ruth Pelk was a Bible study teacher. She let them in. Once inside, the girls attacked Pelkey, and 15-year-old Paula Cooper inflicted fatal wounds with a 12-inch knife. They left with $10 and Pelkey's 1976 Plymouth. Pelkey's final words were reportedly, "The Lord's Prayer." Cooper pleaded guilty on April 21, 1986, with no plea agreement. On July 11th of that year, the judge sentenced her to death by electrocution, making her the youngest person on death row in the United States. She was 16. Her co-defendants received sentences ranging from 25 to 60 years. Cooper's background included attending 10 schools by the age of 15, a juvenile record, and testimony about witnessing her mother being harmed by an assailant, and surviving a suicide attempt in which her mother ran a car in a closed garage with the family inside. The international response was immediate and enormous. Young appellate public defender Monica Foster took over Cooper's case in December 1986, joined later by a law professor named Victor Stribe, who had become the country's leading scholar on the juvenile death penalty. A petition gathered over 2 million signatures in Italy alone. A separate United Nations petition collected roughly 1 million more. Pope John Paul II personally appealed to the governor of Indiana. 60 Minutes profiled the case. The Indiana legislature raised the state's minimum execution age from 10 to 16 in 1987. Then, on July 13, 1989, the Indiana Supreme Court vacated her death sentence through appellate review, citing both the state constitution and the United States Supreme Court's 1988 ruling against executing those under 16 at the time of offense. Her sentence was reduced to 60 years, the statutory maximum for a juvenile. This was not executive clemency. It was an appellate court correcting what it determined was a constitutional violation. And then something remarkable happened. Bill Pelkey, Ruth Pelkey's grandson, a Vietnam veteran and steelworker who had initially supported Cooper's execution, experienced what he described as a spiritual conversion in November 1986. He forgave Cooper. He wrote her hundreds of letters. He visited her 14 times. He founded an anti-death penalty organization called Journey of Hope in 1993, and later wrote a book about his experience. You would think someone would have said something about the contradiction of a murder victim's family member becoming the loudest voice against the sentence. Nobody did, because Bill Pelkey's sincerity was never questioned. In prison, Cooper earned her GED and a bachelor's degree in humanities. She was released from Rockville Correctional Facility on June 17, 2013. After approximately 27 years, through accumulated good time credits. She left with $75 and donated clothing. The attorney who had saved her life, Monica Foster, hired her as a legal assistant, but Cooper's story does not end with redemption. On May 26, 2015, just after the 30th anniversary of Ruth Pelkey's passing, Cooper was found in a parking lot in northwest Indianapolis. She had taken her own life. She was 45 and recently engaged. She left 4 goodbye notes and a taped farewell. Days before, she had told a friend that the pain inside her had never gone away, that she just wanted it to be over. To her fiancé, she wrote that she had taken a life and never felt worthy. Her case is widely credited as a catalyst of the movement that ended capital punishment for juvenile offenders nationwide in 2005, with the Supreme Court's ruling in Roper v. Simmons. Alex Marr's 2023 book, 70 times 7, offers the most comprehensive retrospective of the case. But Cooper's final act forced a harder conversation, one about what 27 years in a cell does to a person even after the door opens. Release is not the same thing as repair. And that conversation continues to shape how states handle mental health support for long incarcerated juveniles upon re-entry. The cases so far have involved girls who acted alone or alongside one other person. But in Madison, Indiana, in 1992, 4 teenage girls committed an act of violence so extreme that it would haunt the town for decades. And the first one to speak was a 15-year-old named Tony Lawrence. Tony Lawrence. On the evening of January 11th, 1992, a 15-year-old girl walked into the Jefferson County Sheriff's Office with her parents. She sat down and, at 8:20 that night, she began to talk. Within minutes, she had named 3 other girls. Within hours, those 3 were in custody. And within days, the details of what had happened to 12-year-old Shonda Renee Scherer would become one of the most disturbing cases in Indiana history. Tony Lawrence had never met the ringleader, 16-year-old Melinda Lovelace, before that night. She was a childhood friend of another girl involved, Hope Rippey, and had come along from Madison, Indiana, for what she may not have fully understood would become. The motive behind the crime had nothing to do with Lawrence. Lovelace was consumed with jealousy over a girl named Amanda Heverin, and she believed Shonda had taken Heverin away from her. Lawrence herself had survived abuse as a young child and had been harmed again as a teenager, details that her defense would later present as context for her inability to act. On the night of January 10th, Lawrence went to Shonda's door alongside Rippey and lured the 12-year-old out under the false pretense of taking her to meet Heverin. Over the next several hours, a prolonged act of violence was carried out primarily by Lovelace and the oldest member of the group, 17-year-old Lori Tackett. During every stage of the escalating brutality, Lawrence remained in the car. She later testified that she had urged the others to let Shonda go, that she had held the girl and tried to comfort her, and that she had been too terrified of the group to intervene or leave. Shonda's mother, Jacques Vaught, has consistently rejected that explanation. She has pointed out that Lawrence spent roughly 4 hours at Tackett's house during the ordeal, with multiple opportunities to pick up a phone and call for help. The other defendants never threatened Lawrence. Her silence, Vaught has argued, was a choice, and somehow it gets worse. When Shonda was discovered the following morning by hunters on a rural road, she had been set ablaze. The violence she endured over those hours is among the most extreme in any American juvenile case. But Lawrence's role in breaking the case was undeniable. Her confession that evening was the principal evidence that enabled the arrests of Lovelace and Tackett the next day. Without her statement, investigators would have had far less to work with. Lawrence was initially charged with murder, arson, battery, criminal confinement, and intimidation. On April 22, 1992, she became the first defendant to take a plea. All charges were dropped except one count of criminal confinement, resulting in serious bodily injury, in exchange for her full cooperation and testimony against the other 3. On January 28, 1993, the judge sentenced her to the statutory maximum of 20 years, telling her she had a future ahead of her and encouraging her to pursue education while in prison. She had attempted to take her own life while awaiting sentencing. Lawrence was released on December 14, 2000, after serving approximately 9 years. Under Indiana's good time statute at the time, inmates could effectively halve their sentences with clean conduct, which is how Lawrence served roughly 9 of 20 years. Former prosecutor Guy Townsend later confirmed this to media in 2019. Her release generated comparatively little public protest, a reflection of both the prosecution's own assessment of her limited role and the terms of her plea deal. She is the only one of the 4 defendants whose release did not spark significant public outcry. She remained on supervision until roughly 2002. Lawrence's case comes down to a single, uncomfortable question about what it means to stand by. She did not inflict physical harm, but she was present for the abduction, knew what was unfolding, and did not act. Indiana's handling of her case reflected a judgment that her presence and knowledge warranted accountability, while her passivity warranted leniency. Authors who have written about the case present her as a traumatized teenager overwhelmed by violence she never anticipated. Jacques Vaught has consistently and forcefully rejected that framing, noting that Lawrence had access to a telephone at Tackett's house and that no one ever threatened her. The tension between those two readings, trauma-driven paralysis versus moral failure, has never been resolved. Whether those two conclusions can coexist comfortably depends on how much weight you give to fear as a defense and how much you believe silence in the face of violence is its own form of participation. As of 2026, Lawrence has not appeared in any verified media interviews since her release. Unconfirmed reports place her in the Madison, Indiana area, living under a different surname. No arrests, violations, or reoffenses have been reported. Her post-release supervision ended nearly a quarter century ago. If you like this video and haven't subscribed yet, now's a great time to join. We post a new case every day, so hit subscribe and don't miss what's coming next. Hope Rippey. There is a booking photograph of Hope Rippey that has followed her for more than 30 years. In it, she is smiling. Not a nervous smile, not a confused one. A wide, open smile, the kind a teenager might give at a school picture day. She was 15 years old when that photo was taken. Hours earlier, she had poured gasoline on the body of a 12-year-old girl. That photograph would become one of the most recognized images in Indiana criminal history, and it would make every appeal for leniency exponentially harder. Hope Rippey was the youngest of the 4 girls convicted in the passing of Shonda Scherer. She grew up in Madison, Indiana, where her parents had separated and reconciled, and by her family's own account, she had been self-harming and had fallen under the influence of the more troubled Lori Tackett. Before January 10, 1992, Rippey had never met Melinda Loveless, but her involvement that night went well beyond standing by. Rippey drove the car back to Shanda's house to retrieve her a second time. She drove while Loveless held a knife to Shanda's throat in the back seat. At an abandoned building, she helped restrain Shonda while others inflicted harm. She took the girl's Mickey Mouse watch and reportedly danced to its tune. And at the burn site on Lemon Road, she poured the gasoline. The sentencing judge would later call that act decisive. Rippey pleaded guilty to murder, felony murder, arson, and criminal confinement. Her case was transferred to St. Joseph Superior Court in South Bend, where Judge Jean Jourdan presided. On June 2, 1993, Jourdan imposed the maximum 60 years, structured as 40 for felony murder, plus 20 for criminal confinement, running concurrently, with 10 years suspended for mitigating circumstances. From the bench, Jourdan said that Rippey had choices, that there were ways to help herself and ways to help Shonda, and that she poured the gasoline so no one would get caught, even though she knew it would end Shanda's life. The judge called her lack of mercy a horrifying lesson. In prison, Rippey earned her GED, an associate's degree, and a bachelor's degree from Ball State University. She trained seeing eye dogs. On November 3, 2004, a judge granted a sentence modification that moved her earliest release date from 2017 to 2006. The details of the reduction have been reported differently by different sources, with some describing it as suspending additional years from the felony murder term, and others as a reduction from 50 to 35 years. But the effect was the same. Rippey's release came more than a decade sooner than originally expected. That modification became one of the most controversial legal maneuvers in the case. On April 28, 2006, Rippey was released at age 29 after approximately 14 years at the Indiana Women's Prison. She completed 5 years of parole, which ended in April 2011. 1 month later, she appeared on Dr. Phil for a 2-part series about the case. where she was confronted face-to-face by Jacques Vaught and Shanda's sister Paiji. Rippy apologized, but maintained she had not known the plan was to take Shanda's life. The family disputed that claim, citing testimony that Tackett had told others the day before that they were going to end a girl's life that night. The sentence modification fueled public anger that never fully subsided. Critics, led by Jacques Vaught, argued that the modification rewarded sophisticated litigation rather than genuine accountability. Former prosecutor Guy Townsend told media in 2019 that the Scherer case illustrated the need to separate juvenile sentencing from standard good time formulas, a reform Indiana partially undertook in 2014, but which was not retroactively applied to any of the 4 defendants. Supporters pointed to Rippy's degree, her rehabilitation programming, and the service dogs she had trained as evidence the system had functioned as intended. That's not a typo, by the way. 14 years for pouring gasoline on a 12-year-old. Indiana's good time credit system made it possible, and Rippy's legal team made it happen. As of 2026, Rippy is a registered violent offender in Indiana. She has gone by the name Anna since her release and has reportedly married a partner named Alicia. No verified news outlets have reported any violations, arrests, or reoffending since her parole ended. Her official supervision has concluded. Of the 4 girls who harmed Shanda Scherer, Rippy poured the gasoline, but the one who carried out the most direct and sustained violence was 17-year-old Lori Tackett, and her path through the system would look nothing like Rippy's. Lori Tackett. Of the 4 defendants in the Shanda Scherer case, Lori Tackett is the hardest to reduce to a single narrative. She had the most documented mental illness, the most extreme childhood trauma outside of the ringleader, and she carried out some of the most direct acts of violence. She also served the longest sentence of any of the 4, and she was the only one who never once tried to shorten it. Tackett's background was defined by instability and harm. Her mother, a fundamentalist Pentecostal Christian, once tried to strangle her after discovering she had been changing clothes at school. Social services became involved. Tackett had been harmed as a young child and again during adolescence. She began self-harming in 1991, claimed to be possessed by a spirit she called Deanna the Vampire, and was hospitalized for psychiatric treatment that same year. She was diagnosed with borderline personality disorder, reported hallucinations going back to early childhood, and dropped out of high school in September 1991. She met Melinda Loveless in late November of that year. They became close quickly. Tackett owned the car used throughout the night of January 10th and 11th. She knew beforehand that the plan was to take Shanda's life, and she told Rippy so. At the abandoned building, she joined Loveless in inflicting harm and strangled Shanda with a rope until she lost consciousness. When Shanda was later heard still alive in the trunk of the car at Tackett's house, Tackett went outside with a knife. During the drive that followed, she struck Shanda with a tire iron. She helped carry Shanda's body to the field on Lemon Road, and in most accounts, she was the one who lit the fire. Tackett pleaded guilty to murder, criminal confinement, and arson in exchange for withdrawal of the death penalty specification. Despite extensive defense mitigation based on her documented borderline personality disorder, childhood abuse, and psychiatric hospitalization, the court imposed the maximum 60 years. She was committed to the Indiana Women's Prison and later transferred to Rockville Correctional Facility. And then Tackett did something none of the others did. She did not file a single motion for sentence modification. She did not pursue early release through litigation. She did not hire attorneys to find procedural avenues to shorten her time. She participated in Indiana's Purposeful Living Unit Serve faith-based program, gave a single interview from behind bars to a local news outlet in March 2006, and served her time. Jacques Vaught, who opposed the release of every defendant, has said that Tackett was the only one she believed showed any genuine remorse. Tackett was released on parole on January 11th, 2018. The date was the 26th anniversary of the discovery of Shanda's body. She was 43 years old and had served approximately 26 years, by far the longest of the 4 defendants. Her parole conditions included mandatory treatment related to the nature of the sexual harm inflicted on Chanda during the assault, no contact with children, and 2 years of supervised release. She completed roughly 1 additional year of probation after that. As of 2026, Tackett has kept an intentionally low public profile. No credible news source has reported any arrest, violation, or reoffense since her release. She remains a registered violent offender in Indiana. Her supervision has ended. The absence of any public statement from Tackett since 2018 means the full arc of her rehabilitation, if that is even the right word, remains unclear. For the purposes of the documentary record, she is perhaps the most enigmatic of the 4. Whether her silence since release reflects peace, shame, or something else entirely is unknowable from the outside. But among the 4 defendants, Tackett is the one who complicates the simplest version of the story, the version where the worst offender gets the lightest treatment. She committed among the worst acts, and she served the most time. She never asked for less, and the victim's own mother distinguished her from the rest. None of that changes what she did. But it does make the moral math harder than anyone would like it to be, especially when you consider the person who set the entire night in motion, a girl named Melinda Loveless, whose own history of abuse was so extreme that even the court that sentenced her acknowledged it. Melinda Loveless. Every account of the Chanda Scherer case identifies the same person as the origin. The prosecutor said it. The Indiana Supreme Court said it. All 3 co-defendants said it. Chanda's mother has said it plainly, that if it were not for Melinda Loveless, her daughter would still be alive. And yet, Melinda Loveless's own story begins with a childhood so thoroughly destroyed by the adults around her that the court record is almost impossible to read in one sitting. Loveless's father, Larry, was a Vietnam veteran and a former police officer who had been fired for assaulting a man in 1965. Court testimony established that he was violently abusive toward the family. He harmed Melinda's mother severely enough to hospitalize her and was convicted of battery. Testimony further alleged that he had abused Melinda's older sisters and a cousin, and that Melinda endured harm during childhood that the court heard in detail during her sentencing. Her father abandoned the family when she was a teenager. The church the family briefly attended arranged what was described as an exorcism involving Melinda and an older man in a motel room. After this testimony emerged at sentencing, Larry Loveless was arrested on charges related to the abuse. Most counts were eliminated by the statute of limitations. He pleaded guilty to 1 count and received time served. He passed away in a car crash in December 1998. Loveless came out as a lesbian at 15 and began a relationship with 13-year-old Amanda Hevron. When that relationship deteriorated and Hevron began a friendship with Chanda Scherer, Loveless became consumed with jealousy. She made public threats. She wrote letters containing threats that Hevron gave to a youth prosecutor, who, according to Hevron, did nothing. Loveless recruited Tackett, provided the weapon, organized the abduction, and participated directly in every stage of the violence that followed over those hours. She was arrested on January 12, 1992, and charged with murder, felony murder, criminal confinement, arson, and additional counts, with death penalty specifications. On September 21, 1992, she pleaded guilty to murder, criminal confinement, and arson in exchange for withdrawals of the death penalty. On January 4, 1993, the judge imposed the maximum 60 years for murder plus 20 years for confinement, running concurrently, citing Chanda's age, the nature of the crime, and the 4 to 5 hours of suffering. A 2007 post-conviction petition arguing her plea was invalid because she had been too young to enter an enforceable agreement was denied and affirmed on appeal. Loveless was released from the Indiana Women's Prison on September 5, 2019, at age 43, after approximately 23 years and 8 months. She was the last of the four to walk free. In prison, she trained service dogs through 2 different programs. In a gesture that still divides opinion, Jacques Vaught donated a dog named Angel, after Shanda, for Loveless to train. A documentary called Charlie's Scars chronicled the program and included interviews with Loveless. As of 2026, Loveless reportedly changed her name after release and maintains a low profile. Secondary reporting places her in Indiana or Jefferson County, Kentucky, still involved in service dog work. She is approximately 50 years old. No credible news source has reported any arrest, violation, or reoffense. Whether her supervision has concluded is not publicly confirmed. Loveless's case is the most morally tangled of the 4. She was both a child devastated by abuse and an adolescent who organized one of the most extreme acts of juvenile violence in American history. The Indiana Supreme Court acknowledged her trauma, but found it insufficient mitigation. Her release, roughly 23 years for what was done to a 12-year-old over the course of an entire night, generated national coverage and reopened Indiana's debate about juvenile good time credit. That debate has not been resolved. What happened to Loveless as a child does not excuse what she did. But it does raise a question the system has never fully answered, which is how much weight a person's own suffering should carry at sentencing when they turn that suffering outward. A different version of that question surfaced in Iowa, where a 14-year-old girl named Christina Fetters became the state's youngest female ever sentenced to die in prison. Christina Fetters. On October 25, 1994, a 14-year-old girl walked away from Orchard Place, an unlocked psychiatric facility in Des Moines, Iowa, hitchhiked to her great-aunt's house, and took the life of the 73-year-old woman who had effectively raised her. 1 month before, that same great-aunt, Arlene Clem, had written her a handwritten note asking to be forgiven if she had ever caused any hurt. The note asked if they could try to be nice to each other. Christina Fetters, who went by the nickname Kiba, stood roughly 5 feet tall and weighed just over 100 pounds. She had been placed at Orchard Place and prescribed Prozac. 3 roommates at the facility later testified that she had discussed a plan to take Clem's life and take her truck. On that October afternoon, Fetters and 15-year-old roommate Jeannie Fox walked away from the facility and made their way to Clem's home. After other visitors left the house, Fetters struck Clem with a tea kettle and a cast-iron skillet, then attacked her with a knife. According to Fox's testimony, Fetters chanted the name Anthony during the attack, the name of a man who had abducted and harmed her when she was a child. She took some necklaces and fled on foot, then broke down crying, pounded on neighbors' doors, and confessed to police at the scene. Her case was transferred from juvenile to district court in February 1995. The defense argued diminished capacity, with an expert testifying that Fetters was in a sustained psychotic state during the attack. The prosecution emphasized premeditation through the testimony of her 3 roommates. After roughly 1 day of deliberation, the jury convicted Fetters of first-degree murder. On December 18, 1995, at 15 years old, she was sentenced to mandatory life without the possibility of parole. She became the youngest female in Iowa history to receive that sentence. Her direct appeal was rejected in 1997. Then, the law changed. The 2010 Supreme Court decision in Graham v. Florida and the 2012 decision in Miller v. Alabama struck down mandatory juvenile life without parole as unconstitutional. Iowa began resentencing its juvenile lifers, and Fetters was among the first. In September 2013, she was diagnosed with inoperable stage 4 breast cancer. In November 2013, a Polk County judge resentenced her to life with the possibility of parole, making her the first Iowa inmate resentenced under Miller, and recommended immediate parole given her condition. On December 3, 2013, the Iowa Board of Parole voted to release her on compassionate, hospice-only parole. Board members noted she had not been a model inmate, but found her no threat because of the terminal diagnosis. Her aunt, Nancy Olson, was the only family member to speak, saying simply that it was time for the family to have closure. Fetters was released in December 2013 to a hospice facility in Des Moines. Iowa Governor Terry Branstad and County Attorney John Sarcone agreed the release was humane, but emphasized that each case should be reviewed individually. She had served roughly 19 years. She passed away on July 27, 2014, at 34 years old, after approximately 7 months in hospice. Her funeral was held at New Hope Assembly of God in Urbandale, Iowa. A friend named Jamie Ross told media that the God they worshipped was a loving and forgiving God. Her case became Iowa's first real-world test of whether Miller's ban on mandatory juvenile life without parole should apply retroactively, a question the Supreme Court answered nationally in 2016 with Montgomery versus Louisiana. It also raised questions about how states handled terminally ill, long-serving prisoners, and whether the compassion extended to Fetters was being applied consistently to others, serving time for lesser offenses. Her trauma history, including harm she suffered as a child, psychiatric placement, and a Prozac prescription that was never fully evaluated for its effects, figured prominently in her mitigation arguments. As of 2026, the legal precedent her case helped establish continues to shape how Iowa and other states resentence juvenile offenders. Arlene Kleem's family has not spoken publicly about the resentencing beyond Nancy Olson's brief statement. The case remains one of the clearest illustrations of what happens when the law changes after the sentence has already been served. Every case in this video has involved a girl who was, at minimum, present when a life was taken. The final case is different. Angel Bumpass was convicted of a taking she may not have committed at all. Angel Bumpass. In 2009, a 13-year-old honor student in Chattanooga, Tennessee weighed roughly 80 pounds and stood 5 feet tall. 10 years later, that same girl, now a 23-year-old mother of 2 who was weeks away from starting nursing school, was arrested for a crime that had happened when she was in the 8th grade. The sole evidence linking her to it was 2 partial fingerprints on a strip of duct tape. And the story of how those prints got there and what they did and did not prove would take another 4 years to untangle. On January 16, 2009, 68-year-old Franklin Augustus Bonner, a retired city employee known locally as the Lottery Man, was found by his wife in their Washington Hills home. He had been bound to a kitchen chair with duct tape covering his head, mouth, nose, arms, and feet. The home had been ransacked. Cause of death was suffocation. Police recovered 11 fingerprints and 1 hair from the sticky side of the tape. Initial searches through the National Fingerprint Database returned no matches. The case went cold. 9 years passed. In 2018, Bumpass, then living in Louisville, Kentucky, and raising 2 daughters, failed to appear in court on a speeding ticket. When her fingerprints re-entered the system, 2 partial prints on the duct tape came back as a match. She was arrested on June 14, 2018. An alleged adult co-defendant, Mallory Vaughn, was charged alongside her based on jailhouse informant testimony and a social media connection that, as the judge later noted, did not exist until roughly 10 years after the crime. And no, I'm not making that up. The defense argued that Bumpass, an 8th grade honors student who weighed about 80 pounds, could not plausibly have overpowered a 68-year-old man. They pointed out that the window between her 2:30 afternoon arrival home from school and the 5 o'clock discovery of the body was insufficient for her to walk 2 miles, commit the crime, and return. They noted that she often helped her grandfather in his garage where duct tape was kept, offering an innocent explanation for how her prints could have ended up on the tape through secondary transfer. They also noted that the lead detective on the case, Carl Fields, had been fired from the Chattanooga Police Department in 2015 for misconduct. On October 3, 2019. After about 4.5 hours of deliberation, the jury convicted Bumpass of felony murder and especially aggravated robbery. In a detail that still draws disbelief, Vaughn, the alleged adult co-perpetrator, was acquitted in the same proceedings. The adult walked free. The girl, who had been 13 at the time, was convicted. On November 21, 2019, Bumpass was sentenced to life in prison plus 8 years, with parole eligibility around 2070. On August 31, 2022, Judge Tom Greenholtz granted a new trial and vacated both convictions, citing cumulative errors, including the improper exclusion of Bumpass's 8th grade yearbook photograph, which was critical for showing her size at the time, and improper prosecution suggestions that the defense bore a burden to DNA test the hair found at the scene. That hair was never tested. The tape itself had been destroyed. Bumpass was released on bond on November 3, 2022. Then, on August 8, 2023, Hamilton County District Attorney General Cody Wamp moved to dismiss all charges. The dismissal was granted by Judge Amanda Dunn. Wamp's statement was unusually direct for a sitting prosecutor. She said the state was equally certain that Bumpass did not commit this crime alone, and that a lifetime sentence for this offense was not justice. Bumpass had passed 2 polygraph examinations, one administered at the district attorney's own request. As of 2026, Angel Bumpass is free. The charges were dismissed without prejudice, meaning refiling is technically possible, but practically unlikely. She lives in the Louisville area with her 2 daughters and has stated she intends to resume her nursing studies. The National Registry of Exonerations lists her case. The Franklin Bonner homicide remains officially unsolved. The district attorney has said the investigation has been refocused on identifying the actual perpetrator. The 9 other fingerprints on that duct tape were never identified. The hair was never tested. The tape was destroyed. And a woman spent years in prison on 2 partial prints that may have come from a roll of tape in her grandfather's garage. 10 cases, 10 girls, 10 different versions of the same question. The system gave each of them a second chance, whether through sentencing caps, clemency, good time credit, or a prosecutor willing to say the conviction was wrong. 9 of them are alive and free today, and none has publicly reoffended. What you do with that information is up to you. Thanks for watching. Click here for the next video.